I'm praying for an adjournment in item number 12, madam. My senior is out of station. My senior, Mr. M.K. Chaudhary, is out of station.
Senior counsel, Mr. M.K. Chaudhary is reported legal to is not available to do. Next adjournment list 2 weeks as planned.
God bless.
Yes,
May I pray before Rashid regarding item number 18?
18.
This
What do
matter
you
may
want,
be
sir?
adjourned, my lord, as the petition appellant instructed to me that they will engage another senior advocate.
Then counsel should submit. The appellant is desirous of engaging another counsel and thus come up. The matter may be adjourned. List up 2 weeks as
Please, your lordship, I beg to mention item number 11 for adjournment. Lordship, affidavit is yet to be signed.
6 in adjournment. She has separated an adjournment slip list of 3 weeks.
Kindly oblige.
I beg to mention item number 21 to 23, madam.
Yes.
Here I pray for 1 week's time to file the affidavit on behalf of the Public Works Department, madam. The direction was to file one affidavit against the additional affidavit filed by the appellant, madam. I pray for further 7 days time.
And the counsel, Mr. Sorensen, please is granted 2 weeks time
Date to
to file an affidavit on behalf of the Public Works Department. List of 2 weeks.
Lordship, a date may be fixed, lordship.
10th August,
Lordship,
List of-
it can be on 9th.
9.
Oblige, lordship.
May please, your lordship. Lordship, with regard to item number 25, lordship, here the appellant is not willing to press the matter anymore, your lordship.
Does not want to press.
Yes,
Then counsel, Mr. Sorensen submits that the appellant is no longer desirous of continuing with this appeal and hence he may be allowed to withdraw it accordingly. The instant intra-court writ appeal is disposed of as withdrawn. Caveat is discharged.
much obliged, sir. Item 25. Much obliged, lordship.
I pray for adjournment of item number 27 and 28, your lordship. Both the matters are led by Mr. M.K. Chaudhary. Out of station for the day, your lordship. Any day, your lordship. Fixes.
It is stated that senior counsel, Mr. M.K. Chaudhary, is not available today and thus prayer is made to adjourn the matters. The other side is no objection. List after 2 weeks.
I'm grateful, your lordship.
I humbly pray for listing of a matter appeal on Monday, my lord. We have filed it.
When was the single bench order passed?
Single judge 19/7.
All right. Get it listed.
May it be please, your lordship.
जाके आपका वीडियो नहीं चला कैमरा
May it please, your lordship. Lordship, I beg to mention for listing a matter, my lord, on 25/7, my lord.
20
On 25/7.
25.
Yes.
What is the matter about?
My lord, matter regarding challenging the impugned letter by which debarred the petitioners for transporting cattle from the Bengal to
All
Shillong,
right.
my lord.
Get it listed. Not 25.
Much obliged.
It's a fresh matter, we suppose.
No,
Fresh appeal.
for hearing.
Hearing, then you have to move an application, sir. Move an application. Proper application you move, then we'll grant permission. Okay.
Obliged.
Lordship, I beg to mention for listing for fresh writ appeal, your lordship. Matter was filed on 17th of this month, lordship.
Get it listed in the next week.
Lordship, obliged. May it please, your lordship. With the consent of the other side, I beg to mention item number 30, your lordship. The government has filed an affidavit. We'd like to go through it, your lordship. So may I pray that the matter may be listed in the second week of August.
And counsel for the petitioner submits that the state government has recently herein before filed an affidavit and that he needs some time to study the same and complete his instructions. List after 3 weeks as prayed.
Deeply obliged.
Daily list for orders, item 1.
Wait, please, your lordships.
SLP
Pending lordship.
साइनेड आई adjourn कर देते हैं इसको.
Lordship.
The SLP referred to in the earlier orders has still not been decided. Thus, the consideration of this writ appeal is deferred sine die,
Lordship.
and the same shall be listed again upon an application being moved by counsel for the parties after disposal of the SLP.
Oblige, your lordship.
Item number 2.
Made please.
Elections, what happened?
Lordship, in view of the order passed by this honorable court, one-man committee has been formed. So nothing survives in this retake.
Nothing survives. All right. Then counsel for the appellant submits that in view of the fact that a committee has been formed by the authorities to look into the matters of elections, nothing survives for active consideration of this court in this writ appeal, and hence he may be allowed to withdraw the same. Accordingly, the instant intra-court writ appeal
It may be
Is this-
closed, your lordship.
is closed.
Lordship. Oblige, lordship.
Withdraw मत लिखिएगा फिर ऊपर भी. May be closed. ठीक है. What is the second writ appeal? 115?
That has already been disposed.
That has been dismissed.
That is already.
Item number 3.
Again, SLP pending. SLP pending. Proceedings of the writ appeal have been, instant writ appeal have been stayed by Honorable the Supreme Court, by the order dated so and so, passed in special leave to appeal number 985/23. Thus, consideration of this special appeal is deferred. The instant special appeal is adjourned sine die and shall be listed again upon an application being moved by learned counsel for the parties after disposal of the aforesaid SLP.
Item 4.
The instructions have been given to me yesterday at night. Lordship, may fix the matter for consideration. In the meantime, if I need.
Last date you said that you wanted to counter the allegations.
Exactly, that instruction I have received. In the meantime, I'll file. Lordship may keep it after a week.
Lordship, in the first week of August, Lordship.
Mr. Nath submits that he has received
Lordship,
instructions
Lordship,
in terms of the previous order
Lordship.
and needs short opportunity to do the needful. List on 7th August as prayed.
Much obliged.
Item number 5.
What happened? The representation has been decided.
Yes, that is submitted, but till date we have not been communicated with any.
Lordship will be getting an instruction, Lordship. It's come after some time, Lordship. Matter will be taken up after a week, Lordship. I'll get my instructions.
But the order was passed on 15th May.
Fine, well,
You have to decide it in 30 days.
Lordship, from receiving of the particular representation, so I'll have to get my instructions as to when the
And
representation.
counsel for the respondent seeks short opportunity to complete his instructions regarding compliance of the order dated 15/5/23. List after 1 week.
Item 6.
Lordship, this item number 6, 7, and 8 here, Lordship. Lordship, in fact, last order was that like we should produce the records. We haven't received the records, Lordship. I pray for.
Service on Union of India. You are appearing? Have you got copies? So what are these? What is this supposed to be?
I've given them notice, lordship,
Whom?
to the council.
In Mizoram?
Mizoram.
You'll have to give it here. Learned counsel, Mr. So-and-so submits that he has provided copies of the writ appeals to counsel for the Union of India in Mizoram. However, since the matters are being taken up at Guwahati, principal seat Guwahati, the copies have to be provided to learned Deputy SGI, Mr. R.K.D. Chaudhary, who appears on behalf of the response numbers 1, 2, and 3. Sufficient copies of the writ appeals be provided to Mr. Chaudhary, whose name shall henceforth be reflected in the court list. Mr. Chaudhary pays for and is granted How many days time?
Land acquisition, I can do up to
3 weeks time to complete his instruction. All these important changes. Commander Gref. Give copies to Mr. Chaudhary. इसका तो मतलब नहीं है ना क्या ये वापस दे देना सर्विस तो यहीं करवा देना इसका तो मतलब
What's it? Please kindly give us a date.
whatever date you want after 3 weeks you let us know.
Whichever. Say on 21st August.
21st August. All right.
21st August.
Item number 9.
Where is Mr. KL? John Prakash Meena. Yes. Service has not been effected on the respondent, sole respondent. Steps liya ki nahi liya? Await return of notice for the for 2 weeks.
Item number 10.
Yeah, please, Your Lordship. This IA Lordship is for treatment of the state of Mizoram Lordship.
Mizoram.
They're already represented.
They were party. Any objection?
No, Lordship.
Interlocutory application filed by the Deputy SGI on behalf of the appellant to implead the state of Mizoram, comma, the Secretary to the Government of Mizoram Land Revenue Settlement Department, the Director Land Revenue and Settlement Mizoram, and the Deputy Commissioner Aizol is hereby accepted. Amended cost title be filed within in the main writ appeal within 7 days. List thereafter.
Item number 13.
इसमें लिख दीजिए Mr. Kalita appears on double AG Mr. Kalita appears on their behalf.
What is the report? My lord, report was for they were asked to produce the report, my lord.
My lord, in compliance of your lordship last order, my lord. In compliance. In compliance.
Record is here.
Lordship, yes, my lord. He is there. He wants to address this honorable court, my lord.
He wants to.
Address this honorable court, my lord.
Why? We have not asked for his address.
My lord.
We want to satisfy ourselves.
Regarding my lord.
He has got some extra interest or what?
No, my lord.
Then
That is, my lord. What happened, my lord? As soon as he received my communication, my lord, he has taken all the steps to get the ballot papers. And lastly, he has communicated to the GP who was who has been retired, my lord. So the communication he got from the GP that on last occasion he has handed over the ballot papers to the earlier standing council of the department, my lord. Till now, there has been no communication with regard to that.
Standing council of the department for what purpose?
For some cases.
Maybe. So you try to locate, sir.
There is no reason in that communication, my lord. It may be related to the case, my lord.
So you get the record, you take your steps, whatever. You have to trace the record.
Yes, my lord.
Original record can't be lost like this.
Yes.
Land Government Council submits that the original record had been handed over. The Deputy Commissioner so and so is present in the court. He submits that the original ballot papers had been handed over to the earlier standing counsel of the PNRD department who appeared in the writ court. Hmm? Is that so?
No, my lord, that is, I'm not sure, my lord, but it may be related to the case only, my lord. Now the new set of standing counsels are there, my lord. Now at present, there are new set of standing counsels. My learned friend is appearing for the department, my lord.
He appeared in the writ petition also, writ proceedings.
Yes, Mr. Devnath.
See the appearance,
Yes.
Sir,
but
same
my lord,
counsel.
no, this is my instruction, my lord, that
Then
it has been handed over.
you
to
let
the-
us know. You did not receive the ballot papers. So we should direct an FIR to be filed immediately. What else? Mr. Counsel, get the ballot papers day after tomorrow. From wherever they are to be brought. Or else we'll direct registration of an FIR.
Can it be after till Wednesday, my?
Wednesday, all right. However, the standing counsel, Mr. N.K. Devnath, present in the court, refutes this submission of the deputy commissioner and states earlier means what? Only he was appearing in the writ court.
No, my lord, there are two sets. Now there is a different sets of lawyer for the PNRD department. Earlier, there was a different sets of lawyer for the PNRD department.
Earlier means
Maybe-
writ petition was filed in 21. He has been appearing in the writ petition.
No, my lord, may I clear?
Other case kai ko
There is
dena.
earlier there.
All right.
At the time of motion, there is another set of my lord standing counsel. At the time of motion, my lord. At the time of hearing, he was there.
In any event, comma, we are not satisfied with the explanation so offered. The deputy commissioner, the standing counsel and the deputy commissioner shall ensure that the ballot papers are kept available for the court's perusal on the next date. List on Wednesday, lagha dijiye, 23rd.
Must.
26th.
Can be on 27th.
27th.
It's personal appearance.
If he doesn't come, how will you get the ballot papers?
Item number 14.
This is the, my lord, regarding the.
Old pension scheme.
My lord, 163, table 160.
Admit issue notice connect with rate appeal number
163 of
163 of
2023.
so and so.
Item number 15.
May I please, Lordship? Lordship, this writ appeal deferred against the impugned judgment dated 13/6/2023, my lord. And matter relates for distributorship, LPG distributorship.
Yes.
In first Luckydor Lordship, the petitioner herein, my lord, respondent number 4 was selected. But due to complaint, his selection was cancelled. And that cancellation order, my lord, was communicated to the respondent number 4. That is, Lordship, kindly have a look, Lordship, page 128. There detailed description is there, why it was cancelled.
Page
128.
128.
And it has been received, my lord, by the respondent number 4. And after receiving, my lord, a petition filed by stating false statement that no communication was there regarding the cancellation of the first selection, my lord. That is
Yes.
page, my lord, 70, my lord. It stated a false statement.
Hold on.
Page 70, my lord.
70.
70, my lord.
You are referring to the pleadings.
Yes, lordship.
Yes.
70, my lord. 70, paragraph 5. They are stating that in middle portion, but later on, without giving any notice, the petitioner came to know that his selection was cancelled. So it is a false statement, my lord. Whereas he received this cancellation order. And
So
therefore,
that
my lord,
is, he said,
respondent number 4.
ground is that the cancellation was ordered without adhering to the principles of natural justice. Not that the cancellation order was not conveyed. That is not his case.
And lordship, therefore, my lord, the respondent number cannot be a aggrieved party as my lord, my appointment letter also not been challenged in the writ petition. Appointment letter, my lord, that is page 161. And regarding the prayer and reading in the two writ petition, nowhere the single whisper whether this appointment letter is challenged, nothing is question.
If his cancellation is set aside, your appointment will go automatically.
Lordship.
That's the natural consequence.
And lordship, my appointment letter, lordship kindly have a look, 161.
Yes.
And it is a sub judice, my lord. The fact of this last line, lordship, the fact of this distributionship is subject to the final outcome of writ petition number 4406. And it was argued at the time of argument, hearing of this case, my lord. And it has
Mr. Counsel.
also note, my lord, in the judgment, that is page, my lord, 216, my lord.
Were they required to intimate the successful candidate regarding proposed rejection before effecting the actual rejection? A selection already made, could it have been set aside without adhering to the principles of natural justice? Let us know. Is it permissible?
But lordship, my appointment is a final outcome of writ petition number 4406, my lord. That is also, my lord, sub judice before this learned of my lord. Lordship. And it is also mentioned in the impugned judgment. Even though, my lord, my appointment has been set aside and I am being deprived, lordship.
The respondent number 4 was already selected. By cancelling his selection and appointment, you have been brought in. And he says that I was not given any notice before effecting rejection. How can that rejection stand, sir? Let us know.
No. That was also acknowledged, my lord. This page I have already shown, lordship, page 128. Regarding the cancellation already been acknowledged. And he received this acknowledged.
The receipt is of the rejection. Before rejection, whether any notice was given. This is the 4th time we are asking you. Who is for the oil company? That is all. It's only a direction for fresh consideration. What is wrong in it? Yes. Was the rejection preceded by any notice?
My lord, the rejection of the private respondent was, my lord, it was under notice, ma'am.
Let us see.
Yes.
Where is that notice?
Yes.
128.
Let him see.
Now that page 128.
You are again harping on the same thing. This is the actual rejection order. Whether this step was
My lord,
preceded.
allow me to just for a minute, my lord, the facts, my lord. The private respondent was selected in the first draw of lots.
Yes.
We later on found out that he had
Has
submitted.
changed the name of his father.
Yes.
So his name appeared twice.
Yes.
In any event, if you wanted to take any punitive measure,
Yes.
then you were supposed to
Immediately,
implement.
when we found out that there were 2 application forms, we rejected his application and
So
we
did
informed
you-
him by page 128. It was countersigned. Then we considered his application again, my lord.
My lord is asking whether you have come to a conclusion on your own that this is two names and this is defect whatsoever.
Yes.
Now you, on the basis of that, you have cancelled it. The question is, before cancellation, have you put to notice the person that why this has happened? Any explanation sought for any notice issued?
Yes, my lord, page 128, he has countersigned it, my lord.
That is the delivery, receipt of the cancellation of the notice.
Yes.
Whether prior to cancellation, you have issued a notice to him that we have found this problem. What is your explanation?
Show cause notice.
No.
No, then matter, chapter closed.
My lord, there is no provision in the rules, my lord.
Principles of natural justice need not be existing
The
in
guidelines
rules.
say,
That is inherent in the constitutional scheme.
but then again, my lord, the added advantage which he will get, my lord. I understand, my lord, but we have to proceed by the guidelines. The guidelines say you consider one form. We did. So
What do the guidelines say on the mode of rejection of a selected candidate? Let us read that.
my lord,
Please come out. Read.
Well, the guidelines are currently not on record. my lord. It was placed by me by hand, my lord. My lord, would allow me
Bring
to-
the guidelines.
I'll bring the.
In the judgment, it is quoted, my lord.
It's quoted.
Lordship, I'm appearing for the caveator, my lord.
Hmm.
Page 211.
Yes, read.
It is in the judgment, my lord. Yes. Para 5, clause 10.4.2 is very relevant for the purpose of instant dispute, and the same is quoted here under. 10.4.2, one application per a location. Applicants should submit only one application for one location. In case more than one application is received from an individual, all the applications would be clubbed together and treated as one application. In such cases, application fees received against all other applications would be forfeited. So there is no question of cancelling my selection. That is the correct procedure, my lord, that in judgment itself it is quoted. And
We are-
another
we
thing,
are-
my lord, he has not enclosed, my lord, a reply, and my lord, additional affidavit filed by me. Nothing is, my lord, enclosed here, so that I cannot show the manner.
Your appeal goes on this ground only.
There is income.
You have not filed the complete pleadings. We'll reject your appeal on this ground.
No, my lord.
Then
What the writ petition I have enclosed, my lord?
No, no, no.
What
my
the
lord.
writ petition
Rep-
as well as.
complete pleadings, Mr. Counsel,
Yes,
complete pleadings, all affidavits of all parties.
exactly.
Then I will file my lord, additional evidence.
Then a counsel for the caveator has raised the preliminary objection regarding maintainability of this intra-court writ appeal, submitting that the appellant has not filed complete pleadings, including the affidavits filed on behalf of the respondent number 4 writ petitioner, along with the memo of appeal. Counsel for the appellant prays for and is granted 4 weeks time to bring these documents on record with an additional affidavit.
Lordship, 2 weeks time maybe.
2 weeks.
And in the meantime, my lord.
In the meantime, the process as directed by the learned Singleton shall continue expeditiously.
I'm like,
Bless lordship. High law, bless.
Exactly. Exactly.
Item number 16 and 17.
may please the lord. My lord, the petitioner here in the appellate hearing, he had joined in the service in 2003. Thereafter, till 2000, thereafter he went abroad. He gave applications, and one of his applications was accepted. His leave was granted, and then till 2005, he was abroad, and he had been giving his leave sanction to the appointing authority.
Presuming that it will be sanctioned.
It will be sanctioned. So, my lord, thereafter he was put on suspension, and after putting on suspension, my lord, thereafter he was put on suspension in 2006. Thereafter, my lord, he was the disciplinary proceedings against him was dropped, and he was reinstated. He was reinstated. After he was reinstated, when he joined his
Reinstated is the correct word.
yes, my
Are
lord.
you
Yes,
sure?
yes.
Was there a termination?
No, there was no termination, my lord.
So then how can it be
My lord,
reinstatement?
the word they have stated here is
It would
reinstatement.
be revocation of suspension.
My lord, I'll just, they have said in that on his reinstatement, that is the word they have
Yeah.
used.
Yes.
So, my lord, after I have been reinstatement, as per it has been wrong, actually. So I joined. After I joined, they put my date of joining as 2013, new candidate. I filed a writ petition regarding to that. The honorable court said to give a representation. After giving a representation,
Let us
they-
see that order whereby you were allegedly reinstated.
my lord, page 77, annexure 15.
77. Is a double pagination.
Sri Devasis Pujari, on his reinstatement, he's posted as assistant engineer in PWRD Tinsukia, Rural Road Division,
Mr. Nath.
Tinsukia, against vacant post.
Was it a reinstatement or a revocation of suspension? Plain and
It's
simple.
it's a revocation of suspension.
Plain and simple. So how the earlier service can be wiped off?
No.
There was no termination.
Lordship, in fact, there is another order.
Let's see.
Lordship. That order is not annexed in this writ appeal. There are 2 writ appeals. The second is filed by us.
By you. Let's see.
Kindly come to page 141
Of your appeal.
of our appeal.
Let's see. But your order, which he has read, simply says reinstatement
Yes, sir.
after revocation of suspension order. 141.
141.
Let's see.
This order.
This is show cause notice.
Logic.
Huh.
But after thorough examination of all the relevant document views relating to the case of Sri Devashish Pujari, Sri Pujari is held responsible for his unauthorized absence and foreign trip in absence of the show cause notice. As stated above, Sri Pujari submissive.
Dies non means,
Look,
what does dies non mean?
dies.
Yes.
Look,
Mr. Nath,
logic.
first and fundamental question. Reinstatement can be of a person who has been terminated or removed. Reinstatement can't be of a person who is simply under suspension.
In fact, Lord, what has happened in this case? Lord, he lordship kindly see the first the application of the petitioner for earned leave.
Forget about everything else, Mr. Nath.
Logic.
You satisfy us on this aspect.
My lord.
Whether a person who is never terminated or removed can be reinstated.
Look, although the word is.
And I'm assuming it is reinstatement. So reinstatement is just a consequence of revocation of suspension. Nothing beyond that.
Look.
So if there was no termination, there was no removal, how can the earlier service be washed off?
No, but that is why lordship will kindly see after the 141, page 141, kindly page 143. There are two orders
Let's see.
of same thing. But the period of suspension along with the period of unauthorized absence in respect of Sri Devashish Pujari shall be treated as dies not for all purposes.
Yes, let's see what is the interpretation of dies non.
Logic. Well, the word dies not means in fact in the impugned order also this has been mentioned. But the dies non by legal fiction, dies non bridges the gap of period of unauthorized absence from duty between past and future period of authorized service, so as to enable the employee to get benefit of earned leave and also the benefit of service to qualify for pension, leave and increment on the basis of his authorized services preceding the period of unauthorized absence from the duty. Thus, dies non act as a legal bridge to connect two period of unauthorized services which are distant from each other by void created by period of unauthorized absence from duty. But the order itself, lordship, the projection has been made that the period from the earlier period of 1 year service rendered by petitioner that has been not considered by the authority. In fact, the authority has ordered that the dies non period will be from 31/7/2004 when the leave has been expired. The 30 days earned leave granted to him has expired till the reinstatement, that particular period, because he filed the application that because of some personal reason, he needs 1 year, 30 days earned leave. This particular fact that he has some research work and all these things and has to go to Australia, that was not mentioned. That was never informed to the authority. If lordship kindly comes to.
We understand, Mr. Nath, that you could have punished him. You could have instituted a DP and punished him for that purpose.
No,
you could have removed him.
The another important fact is Lord, because of the election commission notification, a transfer orders were issued where officers are transferred from their place since they have already exceeded 3 years of at a particular place. Because of that, in the interim time, he was not in service. From 2004 August, he was unauthorizedly absent. But because of the election commission notification, that transfer order got issued along with other officers. He never come to the authority. He was not there.
We understand, Mr. Nath.
Complied.
We understand.
Logical.
But is there a specific order that the periods of his absence will not be counted as past service? That is what FR 54, which is reproduced, says.
Yes.
Where there is a specific order.
But the 143 order.
Yes, read.
Logic.
First read FR 54B.
Logic.
When a government servant who has been suspended to reinstated or would have been so reinstated, but for his retirement, the authority competent to order reinstatement shall consider and make a specific order regarding pay and allowances
to be paid to the government.
or the date of his
As it-
retirement or superannuation, whether or not the said period shall be treated as period on spent on duty. What is your order speaking on this aspect? Let's see.
But
Part B, whether you have made any kind of observation in that order.
I'll read both the orders, finding.
Yes,
at page
read,
41.
read. Whether your order refers to 54B.
In fact, Malad, in the representation, which was put to challenge, they have mentioned FR 18. Malad, wrong putting of the rule. Malad,
We understand,
not
but
better.
have you passed a specific order referring to 54B? What would be the fate of period of absence, whether it is period spent on duty
Yes.
or where is that order? Let's see.
Lord. That is the impugned order, Malad, they have challenged in the petition.
You see the findings and then the ultimate order doesn't agree with the entire findings in page 141. Read page 141. Findings. Department moved to the personal department and judicial department for their views in the matter.
In the matter.
Department opined to consider the case so and so. Department opined that the entire period of absence may be treated as rise on,
For all-
apart from taking disciplinary action,
Lordship,
and the entire past services stand forfeited.
Lordship.
Now, your order doesn't say
No.
forfeiture.
Then the order, after careful consideration of all aspects, it is ordered to conclude the departmental proceeding drawn up against the Devashish Pujari with treating the entire absence period as dies non. That is from the period of, that is for the period of 31/7/2004.
For
till
all
date-
purposes under FR 18, not under 54B. Let's see FR 18. What is FR 18?
FR 18 has been wrongly quoted. I also submitted.
Wrongly quoted, then you can't escape the consequences.
But FR 18 says,
Hmm.
unless the governor in view of the special circumstances of the case shall otherwise determine after 5 years continuous absence from duty elsewhere other than on foreign service in India, whether with or without leave, a government servant shall be removed from service after following the procedure laid down in the Assam Disciplinary Services Discipline and Appeal Rules 1964.
So that is exemption from initiating a DP. That is what FR is. You have not taken that step. 54B, a specific order has to be passed. What will be the fate of the periods of absence without leave? No order passed. What is the consequence?
From the record, Malad, they have passed the order, 2 orders, considering that page 141 and 143.
Dies non.
Dies.
Dies on, he doesn't get salary.
Dies.
That's all.
He will not get salary and therefore, Malad, the second part of the judgment, the judgment, that it has said that the seniority has to be given. Now the question is, seniority, Malad, for seniority, kindly see, Malad, seniority in service jurisprudence has reference to continuous length of service.
We understand. We
Malad,
understand. You should have specifically passed an order of break-in service. You would have taken remedies if at all they were available. You had that power.
Correct.
You did not exercise it. What to do?
without having served any service for that entire period.
That is why you have drafted FR 54. That is the reason of having 54 in your rules.
Correct.
Give us any other judgment on this point, that even if there is no specific order, it will be treated as break-in service. Give a judgment.
That they can apply their mind now also.
They can, yes, they can, very well. Why do you need our order for that purpose?
Because the order is already given, Malad, that the seniority benefit has to be given to him.
So
And Malad, he has also filed a writ petition.
that's a situation you have created
Correct.
by not acting as per law. Now, whether we can be asked to read into this order, that this order is under 54B, dies non would include the expression under 54 second clause, B clause regarding
Logic.
fate of service. what kind of indulgence do you expect this court to give to you for your own incompetence?
That the authority ought to have.
What do you want now?
But my lord, in view of the learned single judge's order, which is.
Why are you in appeal?
My lord, I am in appeal because the allowances, the substantive allowances that I should have been paid during my suspension, that was not being paid.
Dies non means nothing, you don't get anything.
My lord, as a judgment, 54(1)A and 54(1)B has to deal with
Man
promotion.
has the gall to do that. He should be happy. We'll otherwise observe that we give them liberty to proceed, pass a fresh order under 54B. All right,
No, my lord.
Take that risk.
I would,
take that risk then. We'll make our order strong. All right,
I would. like
argue
to-
now.
No, in that case, my lord, I would reserve my submissions, my lord, in that respect. Like, I will just say that, I just filed with regard to my allowances, that's it, nothing else was there.
You got far more than you were entitled to. You are lucky that your break-in service has not been done by these people, maybe for whatever reasons. Yes, Mr. Nath.
In fact, the authorities have treated him leniently, my lord.
Yes,
But in view of the judgment, my lord, ultimately, that route is not now, that liberty is lordship gives us, my lord. That.
take your instructions if you want such liberty. Whether it is possible now, you will have to satisfy the court on that also.
I'll check up that.
When you are withdrawing your appeal,
My lord, if the liberty, how can a liberty be given right now? My lord?
that right you will have to contest now.
Lord.
My lord,
That
let
right
the
will
board-
remain.
let the
Of
board-
contesting that liberty, that is the only thing which remains for you.
My lord, let my appeal stay till then it can be.
As jointly prayed, list both the appeals on 24th, 27th July. Mr. Nath, you need to search judgments of Supreme Court. You'll find some judgment
Yes,
to this effect.
I'll.
Definitely. He can't take these benefits in this manner. But unfortunately, your officers have created this situation. On merits, he is entitled to nothing at all. Should have been sent home.
They treated him leniently. Ultimately, they no
The
action.
leniency extended beyond what he deserved.
Correct.
Problem is there.
Yes, Lord.
Probably they had no idea about 54B.
No,
That is what appears on the face of the report.
correct.
Item number 19.
Yeah,
Made legal.
Yes.
But in this matter, an affidavit has been filed by the UGC. Therefore, would like to file a reply letter.
And counsel, affidavit on behalf of the UGC has been filed. And counsel for the petitioner seeks time to file response public affidavit in reply. List after 3 weeks. Ms. Saikia, there needs to be, there's a very serious need wherein your officers who are heading the administrative posts, they need to be trained in service law. It's a very unfortunate situation right now. You're not here. They're not even aware of the legal provisions. Senior Government Counsel was really embarrassed while arguing the matter.
We'll try to sense it.
That creates unnecessary situations in the court. You have to advise them accordingly.
Item number 20.
May I please, Lordship? Lordship, there is a case, my lord, in the case of my lord, opening of the my lord, medical college. The 93 years old, my lord, civil hospital of the district has been, my lord, the primary service has been discontinued. Now, so far, the emergency service and my lord, child ICU, etc. units are functioning. Now, Lordship, their basic defense which they have taken in their affidavit, my lord, that because of to save the recognitions of the medical college, the existing civil hospital has been closed. Now, Lordship, if you go to the policy and program of the health department,
Okay.
it clearly says, my lord, that in order to, my lord, render the health services, my lord, there must be a bed facility of 2 nurses for 1,000 people, my lord. Now, suppose Nalbari district has 10 lakhs people. Then, my lord, it required 2,000 bed facility must be there, my lord. But this norm has not been complied with till today. Second, my lord, so far this, my lord, the district hospital is concerned, my lord, it is clearly indicated, my lord, the policy says that along with the emergency service, secondary service must also be continued. Lord, I just want to place only 2 policy, my lord.
Yes, sure. So where is the order of closure of the,
My lord, they have amalgamated that, my lord, this is a true position, there is no doubt, my lord. They have amalgamated the civil hospital with the medical college.
what is the location?
My lord, 16 kilometer distance from that existing hospital. But if we see, my lord, the Nalbari district borderline is, my lord, suppose 30-40 kilometers away, Satyabari line.
What we are asking you is, they've amalgamated on papers or whether the medical facilities are being still provided in the old hospital.
Yes. Only
What are the
one-
facilities which are being provided?
That primary and secondary service has been discontinued,
Okay,
and emergency service and child ICU, that ward is still.
that is
functioning.
continuing.
Yes, ma'am.
So you want OPD and emergency, the secondary services.
Primary service, my lord. And my lord, it will, my lord, help to the people at large, my lord. There is no, my lord, doubt to that effect, my lord. And my lord, so far this new medical college is concerned, my lord, newly established, my lord. It needs time to make it, my lord, full functional, my lord. And it has been set up to the border of the district, my lord, my lord.
So in the, probably you should search for an order which we passed in Rajasthan. In similar situation was there. We directed the government to continue the district hospital as such.
Exactly, my lord. It is required, my lord.
All right, let's see the policies and what are the orders passed.
My lord.
Let's see.
Lordship, kindly see. They have issued. Lordship, kindly see their affidavit, my lord, for a moment.
For affidavit of,
My lord, respond number.
let's see, yes.
2, my lord.
Yes.
Page 175, annexure A. Now, Lordship, they didn't clarify that under what policy this amalgamation is permissible. There must be a policy, my lord. They cannot act at their own whims, my lord.
These are all only administrative arrangements.
My lord.
What about the actual facilities?
My lord.
This order notification you are showing, these are all only administrative arrangements.
Actually.
What about the medical facilities?
My lord, medical facility in their affidavit they have stated that emergency service continue. It is a fact, my lord. There is no doubt to that. We have also mentioned.
What services have been discontinued? Where do we get that from?
My lord, the health department will continue the primary and secondary service if my lord lordship, my lord, pass necessary direction.
Where have they said that we are discontinuing those services?
My lord,
Where have you said it? Let's see. What has been discontinued?
my lord, in our read petition we have stated, and in our affidavit they have also, in their affidavit also they have stated.
Let's see. Read that, please. Ms. Tamaria, you are not very ready, very prepared.
Prepared, my lord. Lordship, I am trying to assist, my lord. Lordship, kindly see page
Their
170,
affidavit
paragraph
says
7.
that this amalgamation is not only peculiar to Nalbari. They are doing it for all medical colleges across the state. Read para 4.
Yes, my lord. That at regard to the statement made in paragraph number 7 to 10 of the public interest litigation, the deponent begs to state that the decision of the amalgamation is not only for the medical college, but all new medical college of the districts. When there will be a medical college in the district, the health facility will be upgraded, then the healthcare facility of the civil hospital. Further, this facility will be for the poor and needy people, and Soed Mukunda Kakati Hospital cannot be an exceptional one. My lord, out of 13 medical college as on today in Assam, I have given the data, my lord, in my read petition. There are 4 medical colleges where still, my lord, that district civil hospital are still functioning, my lord. Silchar, my lord, Borpeta, Nogao.
They are in the position of transition.
Right.
They are in the position of transition. That's what they say.
Right.
And this is for the betterment of the facilities.
Right.
What is wrong in it?
Right.
Emergency services, they will continue.
Right.
Specialized service you want, you go to 16 kilometers. What is the problem?
No,
There is an AIMS in Jodhpur.
Right.
People from 400 kilometers away come for specialized medical care.
Right.
So what is wrong in it?
The question is that, my lord, yes, once there is special service required, my lord, person move, my lord, to the particular.
Now, there's a proposal we give. All right, we grant the power to all the district judges to exercise writ jurisdiction. What happens?
No, my lord.
So there has to be some kind of centralization.
My lord,
somewhere.
kindly see, my lord, from the-
Specialized services,
my lord,
specialized
kindly see, my
facilities.
lord, two perspective, my lord.
You can't have at every spot.
But two perspectives are very important, my lord. First thing is that, my lord, my lord, two policies are very important. If it has not been followed, my lord, then, my lord, they are the
What
violator.
policy? What policy?
First policy, lordship, kindly see. I have given, my lord, section 4.
Of
Yes, no, not my lord.
Public standard.
Yes, my lord.
yes.
Section 4, my lord, flag mark I have given. Urban HWC PSC, my lord. In urban area, assured round the clock emergency and secondary care services are readily available owing to the presence of the higher level healthcare facilities. That means, my lord, emergency plus secondary service is essential, my lord. It has not been followed. Now, lordship, kindly see the second, my lord, the important part, national, my lord, health policy. I have given the flag mark, my lord. Where it is stated, my lord, in what manner? 3.2 point, my lord. 3.2. Where, my lord, is stated, lordship, kindly see that in each district, secondary service is essentially required. And, my lord, suppose if civil service, hospital will continue the secondary service, how it will assist the people at large, my lord. Medical college is assisting, no doubt, my lord.
What precisely is the definition of secondary services?
Secondly, my lord, that all is like orthopedic, my lord, eye specialist, my lord, gyno, everything is available there, my lord.
You can't have that number of doctors. Are they available in the government services? Let us know. Every day they are facing the problem of doctors resigning.
My lord,
Where will you get specialists from?
my lord,
Specialists they will
my
send to
lord,
the college.
My lord, primary service, my lord, primary, my lord, the facility, my lord, basically confined to the rural area, my lord. And so far the district hospital is concerned, my lord. Kindly see, my lord, secondary service, my lord, because the last people are required, my lord, medical, my lord, facility. And whatever, my lord, doctors are, my lord,
16 kilometers is not such a big distance, Mr. Counsel.
but from district, but other, my lord, those who are getting the facility from the civil hospital district, suppose 30 or 40 kilometers away from.
Yes,
both
so
the part-
if person comes from 40 kilometers, he will travel 10 kilometers more.
My lord,
What more?
but it is not the case of, my lord, yes, lordship.
And
quite
then
right that-
on the bordering area of the hospital, people from the nearby districts will be benefited.
My lord, kindly see, they have minimized the requirement. If suppose this hospital, existing hospital had 237 numbers of seats earlier, my lord. Now that has been reduced to the 50 as on today by, my lord, facilitating that only emergency service. And my lord, they want to say that we have diverted this seat to the, my lord, new medical college.
Yes.
But the ratio which required as on today, my lord, under national health.
You can, what request you can make is that enhance the facility in the medical college.
My
That
lord,
is the proper
my lord,
relief which
they
you should
cannot,
serve.
my lord, as on today, it's a newly establishment. my
They
lord.
will do it.
But-
They will definitely do it. That is why they have gone out 16 kilometers
My lord,
because they don't have space inside the city.
So kindly see for a moment, my lord. It's my lord, the larger interest, my lord, that so far this, my lord, the existing hospital is concerned. If suppose it will be continued, my lord. What
It
will
is
harm-
being continued. You yourself say emergency services are being provided.
This is not.
Childcare is being provided. What else?
My lord,
ICU is there.
My lord, that emergency service is not, my lord, enough, my lord. Question is that, my lord, if suppose the local people will get the other facility which otherwise require under policy itself, my lord, let them follow the policy, my lord. If suppose policy demands certain thing to be done in certain.
All
manner,
right, let us see what do they say about the policy. Okay.
What is his prayers, Lordship, page 35?
Mm.
His first prayer is that mandamus directing the respondent 2 and 5 not to amalgamate the Suhid Mukunda Kakoti Hospital
Mm.
with Nalbari Medical College.
Mm.
This amalgamation was done in the month of April 2022, and he filed this application in May 2023. He was sleeping.
Mm.
First prayer. Second prayer, directing the respondents to maintain the earlier status of Sohit Mukunda Kakoti Civil Hospital, Nalbari, and allowed to make it functional as a separate unit.
Mm.
So separate unit we are not doing. Page 171, Lord, if Lordship is please, a part of our affidavit.
170.
171.
Mm.
That apart, Sohit Mukunda Kakoti Civil Hospital, Nalbari shall not stop functioning.
Yeah, that he himself
Instead,
says.
it will be converted to first referral unit, FRU, and the
Mm,
cancer hospital will be established at the side of Sohit Mukunda Kakoti Civil Hospital, Nalbari,
Okay.
which will be beneficial to the people of the district.
Mm.
So we are all upgrading the things. And third prayer, a writ in the nature of certiorari, thereby setting aside the notification dated 28/4/2022 issued by the respondent number 3. So they are asking for setting aside of the amalgamation order. It was too late in the day because on the basis of this amalgamation, the whole property was projected before the National Council Lordship, and they have approved the recognition, and we are admitting 100 students from this season. So it is too late in the day. All the things are settled. Now it cannot be unsettled at the whims and fancy of some people who are not even a recognized organization. They themselves have said, although they have said the petitioner is Sohit Mukunda Kakoti Civil Hospital Protection Committee, but it is unregistered as indicated in paragraph 2 of their affidavit at page 7. It is an unregistered organization in the PIL. So my humble submission is that, Lordship, nothing is degraded, rather it was upgraded. Additional facilities are coming, and the distance between the Mukunda Kakoti and the Nalbari is only 10 kilometers, not 60 kilometers as he is 10 kilometers, and it is a part of the scheme. In Guwahati Medical College also, there is another cancer institute, a part of the Guwahati Medical College and Hospital, and that is called Guwahati Cancer Institute. Wherever we are developing the district hospitals and upgrading it to now about 13 are in process. And very soon we are going to have 22 numbers of medical colleges in the state, which was only 3 till 2010. Now we are 12. And the process is that we should have 23 medical colleges in the state.
Rajasthan plans to have medical colleges in every district.
Yes, that is
So that
our
is what the
that
focus
we are following Rajasthan model, Lordship.
Have to do it.
We have to do.
Everyone has
So
to
now
do that.
Karimganj, Lakhimpur, all these things. This year 3 are in the pipeline, which are going to
Setting up of
start.
a medical college improves the facilities, gives
Exactly, Lordship.
possibilities of the
They
students.
want to go us in a negative way, which is not required, Lordship. It is not in public interest. They may have some vested interest here.
Okay. Anything else, Mr. Chamaria?
My lord. My lord, so far, my lord, that affidavit of the respondent of one Union of India is concerned, my lord. It's a matter of policy, my lord, that how that policy has to be implemented in a particular district.
We'll examine whether the policy is being flouted or not.
Yes, my lord.
We'll examine that. All right.
Lordship, their affidavit is still awaited, my lord. Their affidavit is
We
required.
don't
my lord.
My humble son, Lordship, there is an order of status quo that may be withdrawn because we have to go on the last occasion, a stay order, status quo order was passed. That may be,
Lordship, suppose,
Recall.
my lord, that will be recalled.
because
nothing
we are not otherwise
We are
progressing.
disposing of the petition, sir.
My lord.
Thank you.
Highly obliged, Lordship.
Hold on. Repeat.
Supplementary list, item 32.
Appellate Submission. I'm appearing on behalf of the sole respondent matter. On last occasion, matter was at length matter.
What the previous dates and. That's right. Pension system. Where is the government council? Pass over kariye.
Highly obliged.
Item number 33.
May it please, your lordship. Lord, on the very same day I joined, my lord, I was transferred. The lordship will kindly mark the date, my lord, 15/11/22. I was transferred.
Kato.
15/11/22, my lord, I was transferred. Then, my lord, on order was to be effective in the month of April of 23. And 19/4 I was released. And my lord, 24 I joined.
We have kept in a appeal arising of same set of transfers on Tuesday most probably.
My lord,
We listed on same day. Kato, it was there yesterday. Kato wala jo color hai,
I
NNP
think
chocolates.
Mr. Mojumdar appeared.
Yes,
and
same petition.
And my lord, some MLA writing some letter which resulted. Look, status quo till then, my lord. I have not joined. Sorry, I have assumed charge.
So then let it continue as such.
Okay,
We will hear you on the same day.
my lord.
Issue notice to the respondents. Everyone is appearing.
Yes.
So and so appears for the respondents. List with analogous appeal number so and so on 25.
The other case, there is an order of status quo, my lord.
No.
Respondent 5 has already taken charge on 12th of July.
Let's see, 25th July.
25.
There's no stay even in that case.
Okay.
Daily list for hearing, item 24.
May please, your lordship, my lord. In this case, actually, I am paying for a little accommodation, my lord. Because what happened is the appellant, at the time of filing the appeal, you are in the serious condition, you are cancer patient, my lord. But I do, presently, I do not know.
You're not in
whether
touch with him.
My lord.
Then
Let it be-
council
Let it be after 10 days, my lord.
submits that. He's not, the appellant is not in contact with him and he needs short opportunity to complete his instructions. List after 3 weeks.
Obliged.
So as to enable the appellant's counsel to complete his instructions.
Item number 26.
Maybe the lordship. Lordship, this is custodial death matter, lordship.
Custodial death.
Lordship.
Look, yesterday I spoke to the officer in charge. Look, they said that the records were the original case records, all statements have been sent to the honorable court. Sent to us for producing the same before the court. And therefore, they are not in a position to conclude the investigation. Otherwise, everything is ready. we may be allowed to send back the records because the court has requisitioned the records. So that they can.
This is
continue
a-
the investigation.
Petition of 2019.
19, my lord. Yes,
What took you so long to, we called the record only on 11th April.
yes, yes. my lord.
Before that, why didn't you file the
No,
affidavit?
well, my lord, otherwise, I have seen, my lord, all are here. Everything is there.
Has there been any inquiry under 176?
Magistrate inquiry is there, sir.
Is there?
Yes, yes.
What is the conclusion? Is death in police station
No. no.
or in jail?
It is, no, no.
In forest office, Ross.
Forest
It is
office.
the forest range office.
Let's see, what is the report?
Lodge.
Ministerial report, inquiry report.
Lodge.
And what is the status of the FIR?
If the record goes within very short.
You would be able to see it, record is in your hand. What is the status of investigation?
But, PM report and all these things are there. They said that it's a hanging.
It's a
Hanging.
hanging. Let's see the postmortem report. It will take just 15 seconds to discern
Correct.
whether it's a case of hanging or it's a case of murder.
Lodge.
Just see the position of the ligature mark.
In fact, the photographs are there. Which will indicate, Malak. I have my reservations, Malak. I have submitted what the report said.
It takes 5 seconds to find out.
Correct.
Just see the position of the ligature mark. This is possible. You say that because the feet are touching, that is possible. There is a exact illustration in Modi, wherein on the railway sides, the pillars were there, iron pillars, and the man hung himself from the pillars. But this is, let's see the postmortem report.
PM report is there. PM report. PM report is flagged there, Malak, as annexure 10.
Again, inquiry by the subdivisional magistrate.
Yeah.
Not by the judicial magistrate.
No, judicial magistrate inquiry is there.
Violation of 176. Yesterday we were taking that Nilima studio matter.
No.
And in the vision of the forest officers, how could a man hang himself? Where did he get the rope from? Inside the
Inside that particular.
locked up, it's a lock applied outside. Maybe we can assign the investigation to the CID.
Final conclude.
There is the postmortem, Mr. Now.
PM reports is annexure 10. It is flagged there, Malak. Should I, can I just? Malak, I have a photocopy of that.
You know. What is your prayer?
Prayer is adequate compensation and necessary action against the hiring officers. There are 10 of my restrictions.
There is an abrasion. Left neck vessels found bruised. Case of murder, 100%. It's not a case of hanging. Nothing needs to. The distinction is the tissues underlying in a case of hanging will be parchment-like glistening because the flow of blood stops immediately because of the body weight. Whereas in case of hanging, throttling, there's a time gap. during which the blood continues to flow.
Continue.
So the underlying tissues are bruised, ecchymosed. That is the typical sign. It's case of murder, clear cut. Keep your SP present. The SP. So and so.
Vishwanath Chayya.
Vishwanath
Vishwanath Chayya.
shall remain present in the court on the next date. And what is there a guideline for compensation in custodial deaths? What is the guideline?
Yes.
Compensation. Absolutely, commit on other side, but they have approached the Human Rights Commission.
That was taken so much over, Lordship, by the Human Rights Commission.
What has been awarded?
2 lakhs, Lordship, by the Human Rights Commission.
Inadequate. Young boy.
So much, Lordship.
Let's have it on Tuesday, 25th. And Mr. Nath, read Modi. There is a chart.
Yes,
What is the distinction between suicidal hanging and strangulation?
yes, sir.
This is a case of strangulation.
I have gone through in another case relating to Jorhat. I have seen.
It's just the stark difference in the underlying tissues
Correct.
when the dissection is done.
Investigation or pass. But
Yes.
but till then the record will.
Record will be with you.
Lodge. Problem.
Mr. Nath shall retain the record with himself.
Item number 29.
Meet with the Lordship. This appeal has been filed by the Revenue Department, Income Tax Department against Malot and order of the Income Tax Appellate Tribunal. Malone, friend, Mr. Kyle was appearing.
Accommodation only for the day, your lordship.
As prayed by and counsel for the appellant, re-notify after 2 weeks.
Obliged.
I'm deeply obliged.
Yes.
For hearing, item 31.
Please, Lord. But in this petition, my lord, the appeal is against the order passed by the honorable single judge, my lord, directing us to pay the salary for the since 2006 to 2020, when the petitioner has been accommodated as a tutor, my lord.
Accommodated
Yes, accommodated as a tutor. Lord, let me give a
as a tutor.
tutor.
Okay.
Now, my lord, may I just give a brief background of the facts, my lord? Since 91 to 2001, my lord, there have been several irregular and illegal appointments in the state, my lord, and there were screening committees constituted. My lord, the petitioner's case projected in the petition is that, my lord, she was appointed in the year 1997 pursuant to some selection held. And thereafter, my lord, she was appointed and in the year 1999 in a sanctioned vacant post and in the BTAD area. Thereafter, she was transferred to a non-BTAD area and she was attached in some other school. And since 2006, she received salary, and since 2006, after 2006, she has not received any salary. Thereafter, she instituted her first state petition. The honorable single judge directed to place her case before the expert committee, which was constituted pursuant to a division bench judgment. Sudendu Mohanty. Subsequently, my lord, they came up in the second petition with a grievance that their case has not been placed before the Sudendu Mohanty committee, my lord. And thereafter, again, it was directed to examine their cases in terms of the division bench order, my lord. Thereafter, the third writ petition, my lord, which is before your lordship, my lord. The third writ petition, my lord, they claim that they have not been paid a salary. My lord, the state filed an affidavit disputing the appointment of the petitioner. And as it was the BTAD then, the BTAD has also filed their affidavit saying that there is no record with regard to the selection, appointment, and advertisement in respect of the petitioner. Now, the honorable single judge has ignored, my lord, that regarding the validity of the appointment, and has directed to pay the salary if it is found that she has been working till date.
Read para 9 of the order under review.
My lord. The writ petitions of
Review.
review, my lord.
Yes.
On the other hand, so-and-so senior counsel for the writ petitioner submit that no grounds for review has been made out, and the grounds urged were very much pleaded facts in the writ petition, which were already dealt with by this court while disposing the writ petition. He further submits that even the present ground cannot be taken up in as much as the authorities
This
have abandoned.
argument.
My lord.
This is a very important fact.
My lord.
Yes.
Have abandoned the proceeding which was initiated by the so-called notice after submission of the reply by the writ petition,
So
which
there is
would
an
necessarily mean
abandonment of proceedings. What more is what?
the reply, my lord, as because, my lord, we could not
What
find
was
out,
the show cause notice?
my lord. This so-called notice was
Let
why
us see.
her service should not be terminated.
Terminated. So you acknowledge the fact that she was in service.
My lord,
You initiate a proceeding for termination, drop it.
my lord,
What is the consequence? What is the scope of
my
interference?
lord.
there?
Though the so-cause was issued, my lord, to my understanding, my lord, had this termination been issued, then it would have been acknowledgement of the fact, my lord, that she is in service. So-cause notice was issued, she replied,
For what purpose?
my lord,
What was the reply? Let us see that then.
my lord.
Let's see. Yes. Thousand plus. After that. How many such similar people you have regularized in service?
My
The
lord,
number must be running in thousands.
yes.
That's right. So why you are singling out this one lady?
No, not singling out the one lady, my lord.
Then
In fact, my lord, the petitioner also accepted her appointment to be illegal, and she participated in the verification process, my lord. 2012, my lord, we issued an advertisement calling for applications from all the candidates whose service has been treated as irregular and illegal. And all total 12,085 applications were received, my lord. And out of that, my lord, after the screening committee has examined, there were 3 categories, my lord. We divided the applications in 4 categories. Out one category 1 was, my lord, who has been recommended and has been working. Second was, my lord, recommended but discontinued the job. And third, my lord, not recommended but working till date. And fourth, not recommended but discontinued the job. With regard to 1 and this third category, my lord, the cabinet has taken a decision to accommodate them with as a tutor. Those who had the qualification, they have been accommodated as a teacher. And those who did not have the qualification, they have been accommodated as a tutor. And the petitioner was also accommodated as a tutor. That is itself is an admitted fact, my lord, that her and petitioner never challenged that decision of the screening committee that her appointment has been constituted as an illegal appointment. They participated in the process.
Yes, let's see this argument
Malad.
before single bench
Malad.
in the writ petition. Where is the show cause notice?
So cause notice, your lordship will find at page 57. It reveals that you were soon appointed as a teacher in a provincialized lower upper primary school. There are no records to show that you were selected as per rules for appointment as a teacher, as provided by the Assam Elementary Education Provincialization Rules 1977. Hence, it appears that your appointment was made in violation of the said rule.
Appointment was made.
Malad.
It's a fact. You yourself admit.
Malad.
Then you drop it.
But
What is the reply?
Malad. Page 58 has submitted
So all relevant documents.
all
were
relevant
submitted.
documents.
Where
as
then,
regard my-
when was the notice dropped?
It
Where is the
was
order?
17 October 2006. my lord.
Where is the order?
My lord.
17th October 2006 is the direction to stop salaries,
As well as the
dropping of the
so-called-
procedure.
so-called
Where
notice.
is that? Order, notice, order.
The order they have not annexed in the repetition, my lord. It is pleaded in the repetition that on the
Are you
same
having a
day.
copy, Mr. Das? Where is that order of 17th October?
17th October.
Whereby this proceedings post notice were dropped.
Well, there is no dropping, but one, well, page 80, your lordship will kindly say 81. In their affidavit, they have said that the records have been taken by the deputy commissioner, so it is not available. This,
Then how does this finding come to be recorded? That
because it did not continue, therefore, I think, my lord, court for,
would there have been any such presumption, sir?
yes. my
That
lord.
it did not continue. So
Inform you that, but regarding that page 81, your lordship will kindly see. A copy of the service book on GPF balance sheet, it is seen that the petitioner getting her salaries till May 20, the name of the petitioner found at serial number so and so, not included. It is also seen that the petitioner was appointed at so and so, and transferred it to so and so within the so on. Detailed report, I have the honor to inform you that the documents of appointments are not available in the office due to seized by the ZDC Nalbari.
dropping of proceeding.
My lord, kindly have-
What is the fate of this notice?
My lord.
What has been the fate of this notice?
My lord, after the so-called notice and the reply, nothing has been done. my lord. It remained as it is, my lord. Thereafter, but they instituted the first writ petition, and there was direction that their case should be placed before the
Committee.
committee.
What has the committee recommended?
And committee, my lord, in the first instance, my lord, committee, we could not place the case before the committee because the documents were not available with us. If your lordship will kindly have a look at page 84 more for a moment. my lord.
The direction was to consider. So you could have considered and rejected, but non-placement was not your choice.
Subsequently, there was another writ petition, my lord. Again, there was but by this time, my lord, the second writ petition was instituted.
Had to be-
The screening committee process has been initiated and they participated in the screening. committee.
Would not wipe off a right accrued earlier, crystallized earlier, under the earlier order.
My lord. If your lordship will kindly have a look at page 82, my lord, the affidavit filed by the BT.
Yes.
Page 84, my lord, I'll just point out two paragraphs.
If it is found that the has been discharged, who admitted that he has been discharging. The fact that she has been discharging the duties is not disputed.
My lord, that is not this.
So then what is it?
In terms of new policies, you can be still be appointed as a speaker.
My lord.
Hmm. We will be regularized. No. Yes.
This aspect of the matter, my lord, has the determination with regard to the validity of appointment was not decided by the honorable single judgment.
It may not have been, but you were given the liberty to place it before the committee.
My lord.
There the fact finding exercise could have been done.
My lord.
Why didn't you do that?
Now, my lord,
You did not comply.
my lord. Thereafter, my lord, the screening committee, in the screening committee, her name appears in the illegal teachers list, my lord, which your lordship will find at page 123, my lord.
Yes. So illegally appointed teacher
My lord.
is a fact that she was appointed is not in dispute.
My lord.
She has been working is not in dispute.
My lord.
How many of the other illegally appointed teachers have been regularized?
My lord, the after this cabinet decision, my lord, the category 1 and 2, it would roundly would come across 8,500 something like.
Then-
They have all been appointed as a tutor, my lord, accommodated as a tutor, including the petitioner.
Then
So the persons who were working but not recommended, the cabinet took a decision that to put an end to this, my lord, because there are several petitions which were
so
pending.
they,
for this-
now what the relief she seeks to get a salary of a teacher
Get the salary of the teacher. my lord.
or
The
teacher
past-
or
for the
tutor.
Teacher, my lord, past benefits. And in fact, if your lordship will find the accommodation as a tutor, my lord, that order itself contains, my lord, she will be accommodated without any retrospective, without any past service benefits.
But service which she has already offered for that period, you can't deprive her of the salary.
My lord, her,
Admittedly, she has served.
that is not disputed because in terms of the direction of the honorable court, my lord, we have filed an affidavit also, where it has been said that she is working. But the period, my lord, when she was working, that period, my lord, her appointment was illegal. So my lord, by virtue of the
For
judgment
that
of the
very
honorable
purpose,
apex
you
court,
were given liberty to or direction to have her case examined by the committee. You failed to do so.
my lord.
And you can't reap benefits of your own wrongs.
But 2012, my lord, if I'm 2012, when the screening committee invited application, and that decision has never been challenged by the petitioner, my lord. She also accepted.
Then why you continue to use her services even thereafter? If she was not screened,
my lord.
why you continue to use her services?
My lord, till we waited till the outcome of the screening and
Of
screening committee's decision. my lord.
screening committee's decision, when was it given?
It culminated into the decision in 2020, that is accommodation of a tutor.
So till then, you continue to use her services.
My lord.
So it's simply to pay her for what she has
My lord.
worked.
My lord, on this, my lord, I'll rely on a judgment of the honorable apex court, my lord.
Hmm. What salary are you paying her? What is the salary you have paid? Teacher or tutor?
Teacher, she got salary, the scale wise.
Scale. But now she has been appointed as a tutor.
Tutor, she had this appointment letter, I got it in their writ appeal only. She was appointed as a teacher. This teacher was not terminated. I will place one 2016 judgment, my lord. Her service has not been terminated as yet.
As yet.
As yet. And this tutor appointment which I got it says you have to join in service within 15 days, and you will have to forgo all your.
But you have not challenged this order, Ms. Das.
No, but this is not a way, we are not accepting because our order of appointment has not been terminated. Order of appointment of I am giving my 3 judgments of the court. It says, my lord.
Teachers will come. What about all those 8,500? How have you treated them? What is the decision?
My lord,
Have you appointed any of them as teachers?
No.
All have been.
Yes, yes. Among them, there were two lists, my lord. One list one, those who had the qualification of a teacher, they have been regular.
So was this respondent not having the qualification? No. Where have you said so?
Completely incorrect. It's not that.
You're not very clear, Mr. Counsel.
My lord, that was never a ground before in the single judge.
But have you questioned that? Have you raised that objection that she is not qualified to be a teacher?
My lord, they have not disputed that accommodation as a tutor, my lord. They have not.
Accommodation as a tutor is in 2021.
21,
The writ petition was filed long back, decided in 19.
my lord.
What are you arguing?
My lord, no. Their accommodation as a tutor, my lord, they
That order has been passed in 21.
21.
Writ petition came to be decided in 2019. Was it your stand in the writ court that she doesn't have the qualification of teacher?
No, our stand in the writ court was that her appointment, there is no record with regard to her appointment, and therefore their appointments were illegal.
Then why you continued her services? You should have terminated.
That one aspect of your lordship will find the affidavit of the BTAD, my lord, where they have specifically pleaded, my lord, that there was no record with regard to the advertisement select list, and that was never been taken into consideration by the honorable single judge.
What happened to the BTAD teachers? Tell us. BTAD teachers, what happened to the BTAD teachers?
They are all continuing.
This court dismissed their petition saying these are illegal appointment. First, then in read appeal, the policy decision was taken that all will be regularized. Now they are regularized as teachers. They are getting salaries. Is not it?
May I just point out, my lord, one paragraph from the affidavit, my lord, if my lordship allowed.
You try to prepare the matter better.
No.
Need more preparation.
No.
We'll hear it after 4 weeks.
No.
Let's stop. 4 weeks.
4 weeks. Well,
Let it be on the board. Mr. Das.
5 lakhs during the pendency of the case. During the pendency of this case, my lord, your lordship directed for payment of 5 lakhs. And she has got it. But if the case is heard, my lord, the Supreme Court judgment says, my lord, 4 judgments I have given, it says, my lord, nobody can take service free. We are not going on merits. I think this court is not going on merits. Whether the single judge order directing for, find out whether.
Mr. Das, you will have to challenge that subsequent order.
Subsequent order is 20, subject to what your lordship may say. That is validity is for only 15 days, and my first order of.
Whatever objection you want to file against that order, you will have to do that.
That we can do, my lord.
Mr. Das praised that he is desirous of
But that will go before the single judge.
an objection. Well, you can file an objection here only.
Here only.
That since
Yes.
the order dated so and so has been passed to the detriment of the petitioner during pendency of this appeal. After passing of the order of this single judge, he desires to file an objection there against in this appeal. It will be done within next 4 weeks. Thereafter.
Passed over matter 32.
In last occasion, your lordship is asked us to distinguish the case between the earlier division bench judgment. Why the division bench judgment doesn't?
Yes.
Your lordship here, your lordship, first thing we have said that our point is that your lordship at the time of the present with petitioner's provincialization. The new pension scheme is in the force, and in the earlier set of litigations, whole pension scheme was in the force, number one.
What is the
Second, now
direction?
the thing is that, the present petitioner, although till the 2006, he has been working against non-sanctioned post and without any vacancy, Your Lordship. And he was engaged by incompetent authority in violation of the statute, Your Lordship. And Your Lordship may kindly see the division bench judgment, Your Lordship. From the division bench judgment, it appears that those 4,556 employees, those were earlier provincialized, they were working against vacancy, Your Lordship, vacant post. So if
Let us see his appointment order.
his appointment order, Your Lordship, as at page number 63, Your Lordship,
Okay.
as desired by the minister, so and so, Your Lordship, Shri Nur Hussain Molla, son of such and such, is hereby temporarily appointed on master rule basis as secretary of Uttor Goramari Gaon Panchayat, as the post is yet to be sanctioned.
Then the regularization order in action 2,
Yes, Your Lordship.
read that. What is the date?
Yes, 73.
Is
73.
73.
Page 65.
73. Yes, this is the regularization,
What is the date of regularization?
2003, Your Lordship.
That would be the relevant date when he is inducted into service. Regularization can't be against a non-existent post. That you can't dispute. Is it a fact?
Your Lordship, our stand is that since he was engaged by incompetent authority without any vacancy, so his entry into the services itself is illegal.
You have a look at your own policy. Annexure 3, page 73.
So, Your Lordship, yes, it was the wrong committed by us,
Wrong policy by us.
So we
Wrong committed.
subsequently we realized because no posts were created. So in the 2006, posts
Mr.
were
Kumar,
created.
let us know a simple answer. Can a person be regularized in service without there being a post?
Without any post, they cannot be regularized. Your Lordship.
You have your own answer now. Annexure 2 is an order of regularization. Whether that order has ever been altered
Your Lordship, it impliedly altered in the
by
year
provincialization.
2006.
By provincialization.
Yes, Your Lordship. Your Lordship, kindly see, this is not only the provincialization. On the same date, another notification was issued creating post, Your Lordship. Thereafter, this provincialization notification was issued, Your Lordship.
Okay, very well.
So first post comes, then Your Lordship, the appointment, Your Lordship. The sequence is that, Your Lordship.
Come to page 126 now. Even your rectification, what does it read? Ex post facto approval. The GP concerned as regular service against sanctioned post with effect from 30th May 2003.
Your Lordship, this is a small window created by the government so that they get some benefit, Your Lordship. And that is the direct fallout of a single judge judgment, Your Lordship, where the state its own volition, given the undertaking, that state will make provision for their salary.
What is the position regarding the 1,272 GP secretaries? What action have you taken against
Their
them?
case is pending, Your Lordship. Hearing is concluded, now reserved for judgment.
Single bench.
single branch, Your Lordship.
All right, so this division bench judgment will govern that judge.
Definitely, Your Lordship, definitely.
Don't have anything. What do you say?
My lord, I would come to page 80, my lord.
Hmm,
Page 80, my lord.
yes,
My lord, can you see page, para 6, my lord?
yes.
The Assam State, second Assam State Financial Commission, my lord. Here, my lord, reflect that, my lord, the one, fourth line, my lord. 2,390 sanction post of Gaon Panchayat secretaries, including 1,707, my lord. So,
Hmm,
my lord, post already sanctioned in 2003, my lord.
hmm,
And petitioner is one of the, my lord, 1,707, my lord, my lord. And the, my lord, act itself, my lord, provides the, my lord, retrospective effect with effect from, my lord, the 110/1991. My lord would come to, my lord, page, my lord, 86, 87, my lord.
hmm.
This is the, my lord, Provincialization Act, my lord.
Provincialization Act,
Act, my lord. The
Page?
Assam Panchayat Employees, my lord, 87.
87.
The Assam Panchayat Employees Provincialization Act 1999.
Hmm, what is
My
this?
lord, section 223, my lord. Rule
Hmm.
23, my lord. It shall be deemed to have come into force on the first day of October 1991.
Hmm,
Second, my lord, 2A, my lord. Appointed day, my lord. Appointed day means the date on which the act came into force, my lord. Then, my lord, 2B, my lord. Date of appointment. Date of appointment means in relation to any employee, the date on which he is joining the service of Panchayat. So, my lord, have the petitioner joined in service of Panchayat in 1993. And his service was regularized by the competent authority in 2003, my lord. So, my lord, the acts as well as the, my lord, division bench judgment, as well as the notification issued by government, my lord, is covered, my lord.
right.
My lord, kindly see the, my lord, the division bench judgment, my lord. Operating parties pays, my lord, operating party space, my lord, 118, my lord.
118.
118, my lord.
Okay.
118. My lord, last sentence, my lord.
Hmm,
We are therefore of the considered view that the benefit of the provision of the act, including those for pension and other retirement dues, would be available to the provincialized employees in service on and after 110/1991 on the basis of the length of their service reckoned from the date of their initial appointment. My lord, initial appointment is 1993. Even then, my lord, it was a fixed term. Then, my lord, 2003 is the, my lord,
regularization.
regularization. My lord, the act, my lord, also, my lord,
Service.
reflected, my lord,
Hmm,
pays, my lord, page, my lord, 88, my lord.
hmm,
Page 88, my lord, rule 3, my lord. Page 88,
yes.
my lord, rule 3, my lord.
Hmm,
My lord, I'm reading from middle, my lord,
hmm,
from second line. All employees of the Panchayat under the state government shall be deemed to have been provincialized on and from the appointed day on the following terms and conditions. Appointed day means, my lord, when the petitioner joined initially in the service of Panchayat, my lord. So, my lord, there is a deeming provision, my lord. Already, my lord, the service of the petitioner provincialized with effect from the date of initial appointment, my lord. Even while 91 is not taken into account the initial appointment, that the 2003, which is, my lord, issued by the
Regularization.
competent authority, is the, my lord, initial appointment. And thereafter, my lord, notification, my lord, page 122, my lord. It is the, my lord, commissioner secretary of the government of Assam Pension and Public Grievances Department, my lord. Page, my lord, 122, my lord.
yes.
Here, my lord, second paragraph, my lord. Now, in terms of the judgment, this is the, my lord, referring by the division bench judgment, my lord. Referred above, the governor of Assam is pleased to order that the benefit of the provision of the Assam Panchayat Employees Provincial in 1999,
Hmm,
including those for pension and other retirement dues, would applicable to the state government employees, would be applicable to the provincialized Panchayat employees who were in service on or after 110/1991, 1991, 110/1991, on the basis of the length of their service, reckoned from the date of their initial appointment in the service of Panchayat. My lord, same thing, my lord, from the date of their initial appointment, my lord. Nothing remains, my lord. And my lord, even then, my lord, the policy of the government, my lord, in 2009, my lord,
hmm.
office memorandum. Here the petitioner initially appointed as master roll worker in 1993, my lord.
Page.
My lord, I have not enough, my lord, copy is there, my lord.
Read.
Okay.
This is, my lord, relating to the master role and workers employees, my lord. My lord, consequence upon issue of circular so and so dated, my lord, 25/1/2005, my lord, on applicability of new contribution pension scheme in.
Even work chart employees who are working.
My lord, and in the last, the similar other categories of employees also, my lord. The last paragraph, my lord. So, my lord, even they issued the, my lord, provincialization in the 2006, my lord, they cannot give the prospective effect. My lord, it should be given the, my lord, retrospective effect, my lord. This is my humble submission, my lord. And my lord, my lord, the financial, the report of the Assam second, sorry, my lord, the second Assam State Financial Commission also provide the, my lord, my lord, the post of, my lord, 2,390 at the time of their regularization, my lord. Page 16, my lord. Page 16, my lord. Point 3.20, my lord. 3.20, my lord. From middle, my lord, last, it is reported that the service of the, my lord, 1,707 engaged GP secretaries have been regularized by the, my lord, respective GPs. As of now, there are 2,390 sanctioned posts of GP secretaries, including the, my lord, 1,707 GP secretaries regularized by the,
Created in 2003.
2003.
So subsequent to your notification saying that this will be given effect from 2006.
Your
This
lordship,
can't override this report.
your lordship, kindly come to page 81. Kindly, page 81. Your lordship.
What do you say to this?
Yes, their
Assam
answer
State
is
Finance
here.
Commission?
In the page 81, your lordship.
81 years.
Page 81.
Hmm.
Paragraph 7, your lordship. A single bench judgment, your lordship.
Yes.
It is never challenged, your lordship.
Hmm.
From the affidavit submitted by the state respondents, what transpires is that though the service of as many as 1,707 numbers of Gaon Panchayat secretaries were
Now, this
provincialized.
is a wrong government assertion made in the order because this report is there. How do you dispute this report?
Your
The
lordship,
post created in 2003. This fact was not brought to the
we have
notice.
disputed through our affidavit. They never challenged it, your lordship.
Gentlemen, this is your report. Do you deny this? Give a statement right now.
Since by way of an affidavit, your lordship, we disputed it, your lordship.
This is a report of the Assam State Finance Commission. Do you dispute this? Make a statement tomorrow. All right. That we deny this report.
Your
Will
lordship,
you be in a position?
see,
Mr. Kamar, will you be in a position to dispute this report? Your own order says ex post facto creation. Even if we ignore this, your own order of 2018 says ex post facto creation from the you are relying upon that order.
your lordship, before that, your lordship, kindly see the Provincialization Act, your lordship. Your lordship, they are claiming benefit under the Provincialization Act itself. What statute says?
They are
Kindly see, your
claiming
lordship.
benefit of the fact that they have been regularized in service from 2003 onwards.
Your lordship, kindly see, kindly appreciate, your lordship. In Panchayat, there are two categories of employees, your lordship.
We are
First
putting you
category
a
is
special-
provincialized employees, and the
Mr.
second
Kumar.
category is PRIs employees.
You already file your affidavit of your finance secretary saying that we deny this report of the second Assam State Finance Commission.
Let me try, your lordship.
My lord,
Are you sure? We'll record this. That government council says that he proposes to dispute the report of the Assam State Finance.
Because your lordship, disputing that particular facts, your lordship, affidavit is filed in the year back 2008. or
Maybe,
something, your lordship.
maybe in ignorance of this report. All right, we'll record your statement. We'll post it on Monday.
On Monday, your lordship,
Yes, Monday,
more time may be given, your lordship.
Tuesday. All right.
On next Wednesday, your lordship.
We'll keep your finance secretary joining through DC.
Let me take the instruction, your lordship.
Take your
Your
instruction, come back at,
If
if you want us to record this fact, come back at 2 and give a statement. You will be unnecessarily in trouble. Can you deny the report of the Assam State Finance Commission? What are you talking?
Your lordship, I may be wrong, your lordship, subject to correction, your lordship. Some opportunity may be given to us, your lordship.
Come back at
Since-
2, we'll record it before giving the opportunity, we'll record that you want to dispute this report.
No. I will have to take instruction whether they.
That is what I'm saying. We are saying, come back at 2 and make a statement to the court master that you stand by this, what you have said. That yes, you want to dispute this report of the Assam State Finance Commission.
I'll come on Monday, your lordship.
2 o'clock, if you give the statement, then we'll post it on Monday. Otherwise, we'll decide it today. Finance Commission's report, you can't dispute. What are you talking?
Your lordship, in the way back 2006 or 5 or 7, something, your lordship.
All right,
affidavit
forget
has been
it. Then
filed.
we'll decide the appeal right now. Don't worry. We'll decide on what basis the arguments have been made. We'll decide. Yes, impugn order by itself is sufficient. All right. Argument heard, judgment reserved.
Your lordship, I have prepared a written argument.
Yes, you give it to court master को दे दीजिए.